He's a caricaturist in the Gazette. He does political cartoons.
That falls under news reporting, and my feeling on that, although I have not researched that particularly, so this is strictly the opinion of an academic.
Okay.
My feeling of that is, if it's going under the area of news reporting, and it's used in a very limited frame. I mean, I believe he only gets a one frame.
Mm-hmm. Yeah, he only gets the one.
And it's more of a commentary. That might fall under fair dealing here in Canada. If he was using the same character on a daily basis, mm-hmm. day after day after day, well, we've crossed the line. Now the original person that he is parodying may require some compensation. Now, if I'm not, I think I know this one. Isn't he the one who was talking about parodying a lot of government figures?
Yes.
Okay, well, we're not talking copyright here.
Okay,
now.
I'm afraid we're going to have to cut it here. We're going to be right back. This is Know Your Rights on CINQ FM 102.3. My name is Ted Wright, your co-host, along with Karen Marsh and Priscilla Duarte. You're listening to Franco. He's talking about character creation and the law, and we'll be back in a minute.
Frank Talks is sponsored in part by Everything Out of Her Mouth is a Test, a man's guide to the emotional needs of women. Ladies, does your man squash your inner vixen? When you ask him to repeat what you have just said to him, does he look at you like a deer caught in the headlights? Does he think that leaving the game on while you talk to him is a good idea? Is his favorite phrase, "Yes, dear, you are absolutely right"? Does wife or girlfriend mean boring and dull to him? Ladies, don't you wish that he knows what you mean when you ask him if you look fat? Then you need to buy him the book, Everything Out of Her Mouth is a Test, a man's guide to the emotional needs of women. On sale now at franktalks.com.
This is Know Your Rights on CINQ 102.3 FM. My name is Ted Wright. I'm the coordinator of Westmount Legal Clinic. That's my legal stuff. And we're talking with Franco, who wrote a master's thesis on character creation and the law. And Karen and yourself were talking during the break. Continue.
Yeah, well, we were just talking about who goes after, like if somebody were to use your work, who would go after?
When it comes to copyright law, usually the onus is on the creator, meaning that if somebody uses your work, you're the one who's responsible for going after them, nobody else, unless you have a contract with a group or an individual who has promised to take your rights and defend them and make you money. A good example of that, if you're a writer who's written a book and you sign your rights over to a publisher, at that point it's the publisher's obligation, usually, depending whatever's in the contract, to go out and defend the property because they're going to make money with it and send you a portion of that money.
Again, that would be the paperwork prior to...
The paperwork prior to sending out copies of your work.
Okay. Okay, so I mean, like we were talking, with the paperwork that you have to do, is there anything else you have to do prior to? You have a contract?
Essentially, it's this. Whatever it is that you're about to create and go ahead in a creative endeavor, make sure that whoever you're creating with, you all understand exactly what you intend to do with this work. You mean
what you're going to do after the work is completed?
That's right.
I think maybe you might need a lawyer or a contractual writer.
There are actually a lot of books out on the market that you could pick up, depending on what your domain is.
Mm-hmm.
I have found that you don't necessarily need a lawyer, although it's a very good idea to speak to one. It's a lot more of an understanding with your fellow creators. For example, one of my clients was a music group. Mm-hmm. Now, these were 3 musicians who got together to do a project, quote-unquote, for fun.
Okay.
They were going to put together an album of about 10 songs for fun.
Okay.
It was with the understanding that, hey, we're just going to get together and jam and have a good time and make this music, and it was going to be great, it was going to be hot. And halfway through the album, they let somebody listen to it who wanted to produce the album. The music was that interesting, and this guy, who had actually some money in his bank account, decided, yeah, I'd like to produce you guys. And then the real questions came up. Well, wait a minute, we were doing this for fun. Now, you had 2 out of the 3 guys who wanted the record to be produced and released, and you had one guy who said, well, no, I only did this thing for fun. The 3 of them created the music all together, which means that even if 2 say yes and 1 say no, The answer is an overall no, because you need everybody together or not at all. That's a Canadian way of behaving, by the way.
But then if they just went ahead and copied the album or copied the music without the copyright, they wouldn't be entitled to anything.
That's right. It would be an infringement, and any money that come in could actually go to the infringed party, depending on how that turns out.
And then it would be who owns the words and who owns the music.
Look, the biggest problem with this particular group of clients that I was dealing with was that they had intended one particular way of behaving with this created work. And then along the way, 2 out of the 3 decided they wanted to do something else. But nobody wrote down anything. This was all a verbal agreement. So one of the guys said, wait a minute. You know, one of the guys in the 3, and I have to actually look at his side and say, yeah, he has a legitimate point. He never said he didn't want it to go anywhere. He just said they weren't actively going to pursue anything. But the fact that an opportunity came up, this one of the 3 wants to be a professional musician and looking for a record deal. The other one of the 3 just wanted to do it for fun. If they had taken the time to at least write down on paper what it is each expected, these type of details would have gotten cleared up. Either they would never have made the project at all, or they would have made the project with the understanding that if somebody comes by, they're going to behave in a certain way. The fact is, that producer backed out, and that project, half an album full of songs, is sitting on a shelf somewhere. Collecting dust.
I have to change direction here because we've got so much to talk about. Item number 3 in the paper you gave us, the difference between copywriting a character and being influenced as part of the creative process. Written, copyright is automatic. Once the work is in a fixed, tangible form, copyright automatically exists. Thus, it protects the expression of an idea, but not the idea itself. Now, we've got a whole bunch of things, non-copyrighted idea, copyright-protected expressions like aliens from outer space come to live among us on Earth. Well, you know, Third Rock from the Sun, Mork and Mindy, My Favorite Martian, Alf. Where do we go with this?
Okay, the idea is this. When you're trying to figure out whether or not you're crossing a line of infringement, you have to understand that human beings do not operate within a vacuum. They're going to be influenced by everything and everyone around them. But there is a difference between being influenced and direct copying. You know you've crossed the line when what it is you create is so similar to another work that you were influenced by that the public would actually think it's the same work. Now, here another example. I'm a big Jim Henson fan. I love the Muppets. Kermit the Frog is my idol, and I hope someday to grow up to be just like Kermit the Frog. But when I created my puppet show, I did not do it so close to the Muppets that people would be confused between my show, The Paradites, and the Muppets. Although people will say, hey, it's a puppet show, and people will usually think of the Muppets when they hear puppet show. But just watch the program and you'll see that it's different. That's the line of influence.
Let me ask a question. What happens if I'm on the radio and I go, "Hi, Kermie, how you doing?" And I use a voice derivative of the Muppets. Where does that fit in?
Okay, now if you're doing it to promote a product, if you're doing it to promote your show, that might be considered, wait a minute, did he go to Jim Henson Company and get permission to do that? Because being in a very capitalist society, as we are here in Canada, the United States, most people might consider that. If you do it the one time, like you just did it now, in a context, context very important, in a context where, hey, you're just having a good old time and you just decide to talk like Kermit the Frog here on the radio show, Know Your Rights. Well, this is something where you can laugh at, have fun with. That falls under, again, fair dealing. It's all in the context. If you're going to start opening your radio program every single week that way, well, we have a problem here. Because you're making people who are listening think that somehow the Jim Henson Company endorses what you're doing.
So in other words, you're stealing from them through a fake endorsement or a fake allusion to an endorsement.
You're not just stealing, by the way, whatever money that they think they're going to lose being associated with this program.